Good evening, friends. I'm in continuation to my earlier videos, which I mentioned in video number 79, 78, and so on, or 80, 81. So this is my 83rd video, and this is the last topic where an OGB bungalow on various issues, which I said, if it is on possession with the army, possession with tenants, it is in a dilapidated situation, or if the bungalows HOR under our dispute, and there has been no mutation taken for the last 70 years, which will be my coming video. Now here the question is most important. The original HOR expires and the inheritors under a dispute, they forget that they are not just disputing themselves, they are actually disputing a bigger monster, which is the MOD or the local administration of the defense, which will actually be, I remember those words what the Quartermaster General in a meeting in 2012 had said, that Mr. Das, we are on a psychological warfare with you. We are identifying bungalows in stepwise. So this is also one of their steps. They are looking for those HORs who are under disputes. Because when an HOR is under dispute, let's say if one of the HORs is in possession, the other is not. Vice versa. The one in possession is little interested, but he wants the other HOR also to make expenditures if there is any court cases going on, or if there is a court case to be filed. Let's say if you have to fall back to me and get your Janampatris or land records to be dug in. It all costs. Nothing comes free in this world today. So these kind of HORs then get into a problem. So I would request, it's not very easy. It's very tough for the HOR who is in possession of the bungalow, because he is the one who's facing all the rut from the department or from the MOD. He is the one who's maintaining the bungalow, paying those house taxes, and somebody who's sitting far away miles is claiming to the portion which he has inherited. I would say just sit down. You are either 20, 80, 50, 50, whatever may be yours. Don't let your bungalow fall into that prey. Because of your disputes, it may get dilapidated. Because of your disputes, the tenants may they may hound you. Let's say if it is on hire, rest assured you get nothing then. Because neither you will file a dehiring suit, neither will you get compensation. Because two of you will keep fighting. Next 15 years or 20 years, you will remain in court till Supreme Court. So for this fact, I am making this video because many people come to me independently who are HORs of a bungalow, and they would talk in different terms when they talk. But I would guide you today, get down together, shun your disputes for a minute. Just say this bungalow, because remember one thing, an old grant cannot be divided. So the mutation will not be speaking of 20%, 80% or 50-50. The mutation will say Mr. A was the owner, now Mr. A1, A2, A3 and A4. Even if you are 6 people, the names of all these 6 people will come. You can internally make a division of your bungalow, but the GLR will not show that division at all. It will be a combined old grant. So we can keep our fight going on, but we can settle this issue for the department, and we can take this monster forehead. We can actually work. So for an instance, we've got our mutations done. Let's say if the bungalow owner is a 20% holder, his name will reflect in the GLR. Even if you come out with a court winning, it will not happen that his 20% will be reflected in the GLR. No. An 80% will not be written on the first headline. He may be written below because of there the seniority will speak of your age. So let's forget all this. Let's really work. So let us wait for the High Court or the Supreme Court orders between the dispute, but for the department, let's be together. And let's really mutually decide who would be running the financial expenses of the bungalow. One who's not an occupier, is living far off, he would be only looking for pastures. He would be only looking, if tomorrow there is anything to flow in, tomorrow jointly we have to sell this bungalow. Everything will flow in the proportionate of your will, or of the proportionate what your original HOR has asked you to be the owner now. So let's keep that only and let's work forward. Because if we do not work forward, guys, I'm being very honest, not today, not tomorrow, your bungalow will be resumed. So please wake up. Forget this nitty gritty. I'm 30%, he's 80%. Just see what you are today. The major I call is the person who is in occupation of the OGP. I call him the major because he can very easily be contacted. He can very easily be entrusted because he's enjoying that OGB. So then we will move forward. So once all this is done, let's move that application for mutation. Let's not dispute those facts, whether A or B or C or D percentage. Let's get that mutation as an HOR combined. So the first part, the GLR speaks, you are the original HORs of the inheritor. Property would not decay, property would be maintained. Now comes a dispute, let's say it gets settled. Or let's say during this period you want to find a buyer for yourself. So you are now the HOR and the GLR. You can very easily sell the bungalow now. Whatever the ratio again can be divided. So let's grow up, let's move on. Let's not just keep sitting. I have a case where a bungalow is on an amazing site, but the occupier there is not even a 20% shareholder of the bungalow. The rest 80% are not in the physical possession. They don't even have any value. So there are those family disputes playing. The bungalow is under resumption. I know if they don't fight it properly, because A or B, one may like me, one may not like me. So your disputes will remain. You whether like me or you don't like me. I only speak laws. I don't want your liking. I want that this bungalow, even if it goes under resumption, now your compensation will flow in. So your claiming to the compensation will come. Everything will flow the same way. So keep your disputes aside and keep your OGB bungalow one side, because it doesn't give a division anywhere. So we can decide this. So friends, this is very important, and I'm very worried for many cases like this happening, and I know a lot many cases. I just mentioned one. That is why I'm coming up with this video, because this disturbs me, because these bungalows are such bungalows which are very easy target. And if they lose, finally the other bungalow owners in those cantonments will lose, because this would be a recent judgment of 2022. So shun your disputes and let's sit together. Get in touch with me. We will talk sense. It should suit everybody. We're not going to hurt anybody's sentiments of the will made by your father or your grandfather. We need to work further. My goal is simple. My goal is only, even if you have a dispute, civil, it should not hamper your rights towards the old grant. Please, with my folded hands, I request all these disputable people, which I know a lot, get together and let's get those land records. You guys are living in a beautiful, palatial bungalows. It's very difficult to purchase these bungalows these days. These are old grant bungalows, I keep saying. They were never converted into new grants by the Britishers, either in 1793 or 1859 culmination of the regulations. So what are we? We were revenue-free grants? No, we were one of them, but we were even those grants which were paying revenue on our old grant. So we have proprietary rights. I bet on it. Thank you. Good day.